I think his point is sort of actually my point too. Get witnesses prepared. Do you agree? Do you disagree? You know, more time to digest it. So. No state. I think it's awesome. That's the case. So my point is, that's probably a good
Good morning. Do we have everybody that we need for the first item on the agenda? All right, well, good morning. I'm Suzanne Van Wyk with the Division of Administrative Hearings. I'm here under contract with Walton County to act as Special Magistrate for the Major Development Order quasi-judicial hearings. We're going to take up the first item on the agenda, MAJ 25-000039, Garage 30A. I would like to start by asking counsel to make their appearances for the record.
Brooke Davis on behalf of the county, Your Honor.
Okay, thank you.
Your Honor, my name is William Bizette, B-U-Z-Z-E.
And Mr. Bizette, what is your address?
Santa Rosa Beach, Florida. Oh, okay.
Okay, and for council, just to make you aware, the county has now provided microphones for you at council table. I think you have an option. There might be a lapel mic as an option as well. We had noted that in going back and reviewing the video for my purposes in writing orders and perhaps for the clerk's purposes as well, that I'm actually unable to hear your objections and other comments that are made from council table. So if you would please use microphones for that purpose, that would be very helpful. All right, the process of the hearings today will be governed by Walton County Ordinance 25-07. Presentation by the county or introduction of the project by the county, followed by presentation by the applicant. All testimony will be sworn testimony subject to cross-examination. After those presentations, I will open the public hearing portion for these cases. Speakers are limited to 3 minutes, except that a representative of an organization can speak on behalf of its members for no more than 10 minutes. The written recommendation that I will make to the Board of County Commissioners excuse me, will be made within 20 days, unless the parties request to submit proposed recommended orders to me, and then my deadline is extended 30 days. Are there any questions about the procedure we're following today? All right, well then, I've already stated we're going to take up MAJ 25-000039 first. Ms. Davis, you ready to proceed?
Yeah. Your Honor, this is Mr. Tim Brown from the county.
Welcome, Mr. Brown.
Good morning.
Mr. Brown, can you state your name for the record?
Timothy Brown.
And where do you work?
And let me go ahead and swear him in first. Mr. Brown, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I work for Walton County Planning and Development.
And how long have you worked there?
Almost 17 years.
And what's your current job title?
Senior planner,
And how long have you held that job title?
12 years.
And you have previous work experience in planning?
Yes, a little over, excuse me, a little over 35 years.
And as far as the land development code and the comprehensive plan, how often are you asked to interpret the comp plan and the land development code?
Pretty much every day. The senior planners do development review, and as part of our development review process, we have to review these projects against our comprehensive plan and our land development code. So every project goes through that same review.
Have you previously testified in quasi-judicial hearings regarding the comprehensive plan, land development code, and planning?
Yes. Planning Commission, County Commission, and the Special Magistrate.
Have you been qualified as an expert in planning the Walton County Land Development Code and the comprehensive plan previously within this court?
Yes.
And what exactly is your role in project management?
So these projects are assigned to a planner, and then we review them against our code, against our comp plan, and then if they're a minor development, they just have to go to the technical review committee. If they're in the 98-331 scenic corridor, they're required to go before our design review board. If they're a major project, they go the same process. They go to TRC. If they're in the scenic corridor, they go to DRB, then they go to the planning commission, and then they come to this special magistrate QJ hearing.
Can you give us any kind of approximation of about how many projects that you've seen through this process?
Well, this is only my second in this process, but the previous process, hundreds.
As far as the difference of being before the magistrate in the quasi hearings versus the Board of County Commissioners?
Yes.
Okay. So you're saying hundreds within the previous process of going through the same technical review, planning commission, final hearing stage just before the Board of County Commissioners?
Correct.
Your Honor, it's my understanding that the applicant has no objections to Mr. Brown being qualified as an expert in the areas of planning, the Walton County Land Development Code, and the comprehensive plan.
Right, so accepted.
And Mr. Brown, you are a certified planner, is that correct?
Yes, I became a certified planner in 1994.
Brown, can you take a moment and read the blurb to us that you prepared regarding this project?
Yes. Garage 30A, request to approve by final order. Project number MHA 25-00039 is being reviewed by Tim Brown. This is a major development application submitted by Jenkins Engineering on behalf of Garage 30A LLC, requesting approval to develop a 73,020 square foot private club for the storage of high-end vehicles and similar items with a private clubhouse and manager's residence on 4.67 acres with a future land use of mixed use and a zoning category of village mixed use. Property is located in District 5 at 5283 US Highway 98 East and is identified by the parcel number in my staff report.
Can you maybe boil down into some layman's terms exactly what this project, what the request is, what it's supposed to look like?
It's basically mini storage for vehicles. Each one of these buildings will hold a vehicle. It could be any vehicle, but I think the idea is these are classic vehicles. There's 5 buildings. I don't recall exactly how many it holds, but with an elevator, a lift, they can hold even more. But that's basically what it is. It's a mini storage for vehicles.
With an on-site security guard that lives on the premises, is that the type idea?
Yes.
Okay. Right, can you explain the process, how this particular project, what it had to work through to get to this point?
So this is a major development application. So first it went to our technical review committee, which is not a public hearing. Basically, it's to get direction, ask questions. We do allow the public to ask technical questions. Then in this case, it's in the 98 Scenic Corridor. It went before our design review board. Then it went to the planning commission for a recommendation, and then it came to this QJ meeting.
So you mentioned a minute ago that this is zoned as village mixed use, is that correct?
Yes.
What are the components that are required because of that particular zoning?
So this is village mixed use over 2 acres. So that has a mixed use requirement. If it's a commercial development, you have to have a residential component and you have to have a recreational component. So for this project, the on-site security is that person will live there full time. That's the the residential component. In addition, they have to have a recreational component. So in this case, they have a multi-use path that will go from this project over to the side street. And there's going to be a park developed as part of a separate project across the street. So they'll have access to that park. But in addition, they'll have picnic tables, trash can, and landscaping. They'll landscape that whole area of where the picnic table and the trash cans will be.
So this adjacent park that's going in, that is a development order that has already been granted, is that correct?
Correct, and that's their recreational requirement.
Okay. So it sounds like, in your opinion, it would be a fair statement to say that this would encourage harmony between the parcels to fulfill that idea of a village concept?
Yes, so that park, that recreational component will be shared, even though it's being built by the other project, it'll be shared by both projects. So both, whoever, I mean, it's open to the public, but whoever is involved with going to these areas will have access to that recreational area as well.
So it's kind of both of these parcels working together to provide a larger recreation component than what each parcel is doing on their own.
Correct.
Got it. You also said that this project had to go through the design review board.
Yes, that's a requirement in the 98-331 Scenic Corridor.
Can you explain exactly what that means?
So the design reviewer has very broad discretion when it comes to aesthetics. They're basically approving color, landscaping, and lighting. They're not approving the project, but they are approving those elements of the project.
So exactly what is the purview of the design review board? As far, you said that it's the 30A, so this is a
US
scenic
98-331 Scenic Corridor.
Okay. So any project under the Land Development Code, any project that would be developed on that strip of property that's adjacent to those roadways, they have to go through the design review board.
Correct.
For approval
of the aesthetics of the project.
Okay. In order for it to be compliant with the Land Development Code.
Yes, so they have to go through the design review board before they can move forward to the next step. In this case, that would be the Planning Commission.
Did the design review board have any conditions for their approval on this particular project?
Yes, they did have 2 conditions. One was their approval excludes the signage for the project, so once they come in for signage, that will have to go back to the design review board for review and approval. And they gave them a couple color scheme options. So the midnight bronze color scheme is what they approved for this project.
And those conditions are included in your recommendations for final order, is that correct?
Correct.
Do you have anything else to add about the project specifics and its compliance with the Land Development Code or the comprehensive plan?
No, I don't think so. I think we covered everything.
Did you prepare a staff report for this project?
I did.
Your Honor, at this time, I'd ask to move the staff report with its insert and public comments into the evidentiary record.
Right. Any objection, Mr. Bezat? Okay, so I'm admitting at this time County Exhibit 1 with inserts.
And to be clear, Mr. Brown, this staff report, this is something that you compile with input from many different reviewers, is that correct?
Correct, yes.
And then do you make any kind of conclusions on whether this project is compliant with the Land Development Code and the Comprehensive Plan?
Yes, there is one section of our staff report that identifies whether it's compliant with the Land Development Code and the Comprehensive Plan.
And that's a conclusion that you make in your professional opinion after compiling all of these different reviewers, is that right?
Correct, yes.
And in this project, do you have any reservations in saying whether this is compliant with the Comprehensive Plan and the Land Development Code?
No.
Do you believe that, in your professional opinion, this is compliant with both of those?
Yes, I do.
Have you prepared a proposed final order for this project?
I have.
And did you include any conditions for approval on it?
Yes.
And are those conditions items that you gleaned from compiling that staff report?
Yes.
All right, I don't have any other questions for Mr. Brown at this point.
All right, Mr. Bezat, any questions of this witness? All right, thank you. Ms. Davis, any other witnesses?
No, Your Honor, not at this time.
All right, Mr. Bezat.
Good morning again. My name is Billy Bezat. I'm the attorney representing Garage 30A.
Okay.
I also wanted to put on the record, Your Honor, that in addition to being an attorney, I'm also one of the members of the LLC that's advancing this project. So
All right.
I have an ownership interest, but I'm here really as an attorney. I also wanted to introduce Jamie Eubanks. Mr. Eubanks is right there. He's with Jenkins Engineering. Jamie has shepherded this project from its inception when we made a pre-application all the way through today. So he was there at the Technical Review Committee. He was there for the Planning Committee. He was there for the some other committee. I forgot already, but thank you. But at every juncture, he was there, and he coordinated all the experts, the architects, and the other engineers that were associated with this project. And Jamie is prepared, if necessary, to testify. I listened very intently to Mr. Brown's testimony. I reviewed the composite exhibit that the county has provided. I believe that the competent substantial evidence exists right there for finding that this project meets or exceeds the requirements of the Land Development Code and the Comprehensive Plan. And Mr. Brown referenced the staff reports, and of course those staff reports seem to follow every time this project advanced from one committee to the next. And the staff report was very clear on all the standards that we're required to meet, be it parking or stormwater, impervious surface, FAR, all of those things. There's a finding in the record that they meet or exceed the requirements of the comp plan. And so it's our position right now is that substantial evidence does exist today based on what's already in the record for you to make a ruling, Your Honor. We are here, though, to be available for questions either from you or from the public, and also from to have Mr. Eubanks be prepared. And I would say in all of the stages and all of the hearings we've had up to this point, we have had, to my knowledge, I don't think we've had anybody testify on this project. But again, if there are anybody there, we're available. And so at this point in time, what I'd respectfully do is yield my time and wait for that public hearing.
Okay.
Yes,
Thank
ma'am.
you.
Thank you.
All right, then. At this time, I'll open the public hearing on Garage 30A, MAJ 25-000039. Anyone in the public wish to speak on this project? Going once, going twice. All right, then I will close the public hearing on Garage 30A. Anything further from either the county or the applicant at this point?
From the county's perspective, Your Honor.
Okay.
Your Honor, again, thank you for allowing us to be here. And the only other thing I would conclude by saying is we have reviewed the proposed recommended order and the conditions that are associated with it, and we have absolutely no objections to it.
All right, thank you for
Thank
putting
you.
that on the record. I appreciate it. All right, then this will close out the quasi judicial hearing for Garage 30A. Let's take like a 5-minute break and let folks switch seats, and we will take up the Echelon project. The county has notified me that they're working on a Zoom link for some remote participation for this hearing, so we're going to wait for them to get that worked out.
My understanding is it was. Started it the last time, yeah.
Up to. All right, let's go ahead and go on the record on project MAJ 25-000034, and the project is Echelon. Are you ready, Madam Court Reporter? Okay. Is the clerk's office ready? All right. So it's my understanding the applicant has a motion they wanted to make. And if you would state your name for the record.
That's correct, Your Honor. My name is Stephen Tatum. I am here on behalf of the applicant. Yesterday afternoon at 4:55 this time, we received an email with several hundred pages worth of documents, exhibits, and a memorandum of law prepared by the opposition. And at this time, we are unprepared to address several of the things that are raised in that. So we will be requesting a continuance, and I'm not certain if there's any objections.
Okay. Ms. Davis.
From the county's perspective, we were doing some last minute witness preparation, and so we at this point have identified some of the same questions so for my witnesses, we would prefer to be more prepared, but really we would be prepared to go forward today or at a later date. It's really up to the applicant from our perspective.
Okay. All right. So it sounds like there's not an objection. Yes, go ahead. Come on.
Thank you, Your Honor. Kent Seyfert with the law firm of Holtzman Vogel on behalf of four party interveners, Mr. John Owens, Robert Paternoga, Cynthia Lynn Kachenik, and Surfside Owners Association. We would object to the continuance, Your Honor. Yesterday evening, as Your Honor notes how these QJ proceedings work, we did not have to send any documents to the county or the opposition. We did so yesterday, so the hearing today would go more smoothly because we've got, I believe, 38 exhibits, and we're going to submit them to them electronically. Likewise, with the QJ hearings, it's the burden of the applicant and the county to prove that this project meets and is in compliance with the LDC and the comp plan. That's their burden. They should be prepared to do that. That has nothing to do with the documents we may present at the QJ hearing today. So we would oppose the continuance because there's no basis for it in rules or otherwise, and it further prejudices us because we're here to present the case. They should be here to present their case. It gives them an unfair advantage to now see all of our documents, go back and prepare. They provided us no documents in anticipation of this hearing so that we could prepare. So from a fundamental fairness standpoint, it is inappropriate. Now, the one thing that we did present in our exhibits is, I think it's Exhibit 38, is a memorandum of law. And we weren't prepared or are not going to argue that today. It's a memo of law that we submit to you. You consider those legal arguments. And they deal with vesting and notice issues of DRI amendments as to whether this project has any vested rights. That's a legal argument, Your Honor, for the most part. I have no objection to giving the county and or the applicant 30 days after this hearing to submit a memorandum of law in opposition to that or in contradiction of that with legal arguments with respect to that. At a minimum, Your Honor, if Your Honor was going to continue this, then I would suggest all the evidence goes forward today on compliance with the LDC and the comp plan, which everybody should be prepared to deal with today. And any vesting issues or notice issues on those DRI ordinances that we raise in our memo can be addressed at a subsequent hearing by Zoom. We have here today 2 experts from out of town that came in for this hearing. It's already been continued once. As well as 3 other witnesses to present today. So a continuance would unduly burden the opposition in this case. So we would, again, oppose that in light of some of the adjustments that I suggested. Thank you.
Okay. Mr. Seyfert, do you know if the parties have stipulated to intervention by your clients or not?
At this point, Your Honor, we made a request on behalf of Mr. Owens and Surfside a month and a half ago, and I believe the county attorney said at the last county commission meeting that we had party status for those 2. We are obviously have requested party status for Mr. Paternoga and Kachenik, I believe, last week in this case. So I'm not sure who grants that party status. It's real unclear in these QJ hearings, as Your Honor knows, but I know County Attorney Mr. Atkinson represented to the county commission that 2 of my clients did have party status.
Okay. Thank you. Your response, Mr. Tatum.
Your Honor, while I don't disagree with some of the things Mr. Seyfried said about how these particularly work, the argument that they did not have advanced access to our documents is totally unfounded. Our documents have been in the portal and been reviewed going forward for several months now. We were blindsided by several things that they're arguing that may or may not have factual merit. We are uncertain at this time. We've not had but less than 12 hours to look at them. So that is the reason why we need to step back, re-examine this, and then come back to you as needed.
So is your so-called blindsided, is it by the legal arguments that they're making, or are we talking about factual issues?
It is factual and legal. It's both.
Okay.
And some of the legal actually leads into factual application.
Okay. All right. Thank you. Ms. Davis, you indicated that the county was kind of working on, I guess, refining your expert witness testimony for today. Is that based on the information that was received last night as well, or is this something separate and apart?
There was one additional that I think I also, in my review last night of some of the expert reports, there was a factual issue that we had prepared to pose to Your Honor today to kind of allow the applicant and the interveners to make those factual decisions and arguments to you. So for us, it is similar of it's factual and legal. So the only thing I would say from the county's perspective, if Your Honor is inclined to grant the continuance, I do have an SB 1080 concern. If we're getting close to that line of the 180 days, I would ask that we extend. I know we previously in a different hearing had extended that deadline, so I would ask that if the applicant would be willing to waive that 180-day evaluation deadline, so that way, you know, if that's their preference is to allow more time to prepare for their arguments, then we would not be okay with also having that stick hanging over us.
Okay. And specifically for the record, you're referring to the time frame in which the county must act on an application before it's deemed approved?
That's correct.
Okay.
I believe by just requesting the continuance takes care of that problem, but yes, we have no objection to that.
Okay. All right. So I'm also going to refer to the memorandum of understanding, Ms. Davis, that the county actually may reschedule any of the quasi-judicial hearings that have been docketed, and that really all you had to do is amend the docket and provide that to DOA, that we're really not sitting in judgment of whether continuances or changes in the document are made. So with that, since the county is representing to me that they would appreciate additional time to prepare, I will grant the motion for continuance. I would like to know that it's not going to be continued any longer than the next docket. However, since there is opposition and you do have a lot of public here that we're expecting to speak on this application.
I certainly go on the record and say we want to move it as fast as possible also. We have no issue with that, provided that the county can handle us being on that docket. As you know, these things can get really long.
Yes. Just a second, I'm waiting for a response from the county first.
Honor, it sounds like from our clerk's perspective that we would be able to accommodate the November docket.
Okay, thank you. Yes, Mr. Seyfried.
Thank you, Your Honor. I just want to put on the record, from a due process standpoint, we believe that impedes our rights. As they say, no good deed goes unpunished. I didn't have to send these documents at all. I did it to make today go faster. And likewise, from a due process standpoint, if they are not required to provide us all of the additional testimony or any additional documents they're going to put into the next QJ hearing at least 15 days ahead of the hearing, I believe it will violate our due process rights, because now they have all of our documents, all of our arguments that we're going to make. They get to prepare for them. We don't have that same thing. This is not circuit court where we do discovery, we do witness list and all of that. And that's what this is now turned into. So I would ask that the court or the special magistrate rule and make them turn all that over, so this is a fundamentally fair process. Likewise, I would like the ability to have this hearing by Zoom, because I've got several people from out of state. This is very, very not out of state, but out of town. Very, very costly. And I know we did a bunch of customary use hearings up at Defuniak Spring. They've got the whole thing the room set up to be able to do that very, very efficiently, because we had hearings with Judge Green all the time on that. So I would like that accommodation being made too, because of the inconvenience that this is provided to not only me and my clients, but also all these members of the public, so they can participate by Zoom too, rather than having to drive up here. So I would ask that that be ordered in addition to just the continuance. Thank you.
Okay. Any response?
I'm not certain if he was asking that we do this in Defuniak Springs or not, and I would have an objection to that. But otherwise, no objection to participation by Zoom.
Well, what about the requirement that you disclose any additional documents on the docket within 15 days prior to the hearing, though?
Okay, so the hearing, what was the hearing date on the next, November 20th? We can do that.
Okay, thank you. I appreciate that. Well, I'm asking her to respond next, one at a time.
And we would have no objection to that as well.
So if you're going to add any additional inserts or documents to your typical Exhibit 1, the staff report, you can do that within 15 days prior to the hearing, correct?
Yes, Your Honor. My staff will work on amending whatever staff report, if necessary, at least 15 days prior to the hearing, so that way everybody is prepared.
Okay.
And to be clear, the county's position would not have changed, even if we were in the middle of hearing this expert testimony and Mr. Tatum's argument arose at that point of requesting a continuance. We would still, we would be prepared to go forward either way at this point.
Okay, thank you. All right, Mr. Seifert, can you clarify your request that the public and perhaps other witnesses be allowed to participate via Zoom at the November meeting? Were you asking for it to be conducted in Defuniak, or?
Not necessarily, Your Honor.
Okay.
I know we've had some trouble with this setup today, so I was just mentioning the board meeting in Defuniak has the setup, and
Right.
we've used it numerous times with hundreds of people in the customary use hearing, so it works. So, but I don't really, it doesn't matter to me where it's at.
Okay, okay. All right, so I'm going to ask the county to try to work out the kinks. I did note that apparently your Zoom was set up as a webinar instead of a Zoom meeting, which may have played some role in this. Usually when it's set up as a webinar, the folks who are Zooming in actually can't be seen by anyone or participate. They would just be viewing it as if they were viewing a webinar for credit. So just a cautionary tale, make sure it's not set up that way for November.
Again, part of that customer use, the IT person in Defuniak, he sets it up as a webinar, and if you're a panelist, you get to speak, you get a special link so that you can participate in the Zoom normal. And then they have a link for attendees that can just watch, so they can't interrupt, their mute doesn't go off and the dogs are barking or anything like that.
Oh,
So
yeah, but we would want the public to be able to participate in the public hearing process. So, but I'll leave that up to the
I'll work
county
with
to make sure it's set up the best way possible.
IT of
Okay.
making sure.
Thank you. All right. Anything further before we adjourn? All right. Thank you very much.